The hearing is over. I listened to every minute of it while I got this fabulous new hair color and cut. Everything worked out perfectly for me. I'm going to do a couple of videos on this. This is going to be like the general summary of what happened, just to kind of counteract whatever the gossip people are going to say that is going to misunderstand what happened. And then I'll probably do a deeper dive. I've looked at some of the questions you guys have asked that are good. And then I'm also going to do one just about kind of like what we've learned about the personalities and the lawyers in this case, including the judge, from this hearing. So the hearing was about an hour and a half long. There was no ruling. The judge said, I'm going to take it under advisement. He will probably have to rule in the next week or two because they can't really keep going with discovery until he does. It looks like, or it sounds like from the hearing, that people are already asking for things back and forth. And they don't know what to provide until we know which type of protective order we're going to have. The hearing itself was a very normal federal court hearing. Just like I said yesterday, everybody makes their appearances, and then whoever is asking the court to do something gets to go first. That's called the movant. And it was the Lively parties and Stephanie Jones who were asking for the court to enter a protective order over and above the protective order that court typically enters for information obtained in discovery. I also said yesterday that I thought that Stephanie Jones had a better argument, a stronger argument for having some additional protections on discovery from her because of the type of work that she does. And it looks like the Lively people agreed with me because they let Stephanie Jones' lawyer go first, and they let Leslie Sloan's lawyer go first. So rather than starting out the hearing saying, here's why Blake and Ryan's personal information needs to be protected, they started out the hearing by saying, this is why these PR professionals' jobs and careers are at risk if information about how they do their work gets shared, which I think was a very strong strategic move, because that is much easier to wrap your mind around than just somebody's personal information. This was essentially the gag order hearing that we never got to have. I mean, it was basically everybody arguing through the lens of a protective order about who's the bad guy and who's the good guy and what information is okay to share and what information is not okay to share. And they took pot shots at each other just like we assumed that they would, but it was on sort of a subdued basis. I will say, and I'm going to talk more about it in the personalities video, this judge is excellent. I've been in front of a lot of judges over my time, and this judge is absolutely fantastic. The way he ran the hearing, the way he controlled things without yelling at people, but they knew that he was in charge. His level of preparation was outstanding. This guy knows what he is doing. I'm very glad he's on this case. He's going to keep this case going. So what were the arguments? Well, essentially, a lot of it was about the PR people and not about Blake and Ryan. So for people who are really focused on Blake and Ryan or Justin, that was probably pretty boring. What they were really trying to figure out was, to the extent that getting information from all the PR people in the case, so there's Stephanie Jones in her case that has Melissa Nathan and Jennifer Abel. Melissa Nathan and Jennifer Abel are also defendants in Lively's case, and then Leslie Sloan and Vision PR are defendants in the Wayfarer case against Lively. So there's lots of PR people here. And one of the big issues was the things they did for the clients in these cases, like, fine. But what about information related to their other clients? What about the marketing plan that somebody has for a celebrity who's not even in this case? And really it came down to a couple of things. Are those trade secrets? Is how you do your work a trade secret? And specifically, is who you are trying to get to work with you a trade secret? Like, not the clients you have now, but the ones you're going after. And there were good arguments on both sides. I thought if they are a trade secret, they would be covered by the order as it is. So you wouldn't need this over and above that the Lively folks and Stephanie Jones are asking for. Brian Friedman made sure, with regard to the PR folks, to bring up a point that who a PR team represents is not private information. It's all over the place. So to the extent that it's discovered that Stephanie Jones or Leslie Sloan represent somebody that we're not aware of, he's like, that's not a trade secret. It's literally their job to be the public spokesperson for the people they represent. The response to that from all the PR folks was, it's not the people we represent, it's the people we might be going after. And if our competitors they essentially admitted that Stephanie Jones, Melissa Nathan, and Jennifer Abel, and Leslie Sloan and Vision PR, all three of them are competitors of each other. And they're worried about their business being shown to their competitors. The judge made a couple of things very clear. He made it very clear that there is a public interest in this case, and that is okay. He made it very clear that he is not just going to close the lid on this case. He said out and out, I am not going to make confidential stuff that gets filed in this court. I'm not going to do it, so don't even ask me. He did not seem to care about the fact that all the stuff was being talked about in the press. That was brought up a couple of times, and he was like, eh. He did note, he said, I would note that both sides of the case in Lively Baldoni have accused the other of leaking information inappropriately, right? You've both accused the others of doing it. So it's not like it's all the weight is to one side. So you guys just need to behave yourselves. But, the Lively folks were trying to say they've been disclosing everything. And then, of course, Friedman came back and said, well, you originated this by giving it to the New York Times. So the judge didn't seem to want to take sides on that at all. The judge gave more than enough opportunity for everybody to say their side of the case. If somebody made an argument, he would then go back. Does anybody else have anything to say? Judges are usually pretty good about that, but he was excellent about that. He would propose ideas in the middle of someone's argument. Okay, I know you don't like that, but what if we did it like this? Could you tell me if you could live with that? He's thinking of things he might find a middle ground for, and then asking them if they would be okay with that, which is, again, and something that all smart judges do. There was some agreement, I know that's shocking, in the hearing. So first of all, it looks like everybody agrees that medical information, including Blake Lively's medical information, they're not going to leak that to the public. That's private, personal information. Now, when we get to summary judgment, or if we get to trial, that might come out. But everybody, including Brian Friedman, agreed that that is not something that we are going to put out there. That is private information, and it will be covered by the court's standard protective order. During the hearing, and everyone kind of agreed on contact information, I think. Friedman took a little bit of a pot shot and said, yeah, my client's personal, residence address got put out in public. And then the Lively people came back and said it was publicly available information to begin with. So what's the big deal? But I think they all agree on medical and contact information. During the hearing, Lively's lawyer pulled. She said, we're just going to abandon this category they had put in the proposed protective order for high profile individuals, because I think she realized that the judge was just not that interested in it. And they said, you know what, it's not about high profile people. They just there's the parties in the case, and then there's third parties. So the Lively argument really became, we just want to protect the people who are not in the case. Again, it was very little about Lively and Reynolds themselves, other than this issue about security information, which the lawyers were arguing with each other over who was actually right on that. So I'm going to look at that more closely. But it really became about the third parties and how we can protect third parties and to what extent do we need to do so. The lawyering on all sides was excellent. Again, I'm going to make another video talking about sort of the personalities. Everybody did a very nice job. There was no bad lawyering. I thought some were a little bit more effective than others, but they all did a pretty good job. They all cited prior decisions from this particular judge or this particular court, which is a pretty standard thing to do. It's also a little dangerous, which I'm going to talk about next. But you sort of got to see the themes of both parties' side of the case in the Lively Baldoni case. Their lawyers sort of showed us what the theme of their case is, which I think is exactly what we think it is. The Lively case is, someone should not have to be battered and bruised in public in order to claim sexual harassment. Just because you are someone who brings a sexual harassment claim doesn't mean you should open yourself up to be a completely open book. That's not fair. The Baldoni theme of the case is, you're not special just because you're famous. Friedman really hit home, they want all these special rules and special rulings because they're celebrities, and that's not how the law works. And I imagine that the judge is probably going to give them something, but I don't think he's going to give them very much, because I think that there were successful arguments that a lot of what people are worried about is covered by the existing order. So that's the general summary. That's what happened. No ruling. We're going to have to wait. If you have questions, put them in the comments, and then later today I'll try to answer everybody's questions.